The truth is, nobody wants to be on probation. Nobody enjoys being on probation. Nobody likes having the threat of being incarcerated if they step out of line, done so easily, hanging over their head. Nobody likes it. So if you reach the halfway point of your probation, it's strongly advised that you have an appropriate motion filed on your behalf to early term. Now, as of October 2019, we can say that there's two types of early termination motions when it comes to the judge and their discretion. And that's discretionary and non-discretionary. Discretionary being the judge's wide latitude to either grant the motion to early term, or non-discretionary under Florida Statute 948.04 paren 4, which seems to indicate that the judge is mandated to early term a probationer's supervision if motioned to do so. And there's a bunch of nonsense in the statute about how probation officers can file to have a supervised individual early termed, but we don't see it, at least not in South Florida. I haven't seen it once. Now, if you don't qualify for mandatory termination, which we'll get into in a couple of seconds, let's say you've had a violation in the past, the things that the judge is going to look at in choosing whether or not to grant your motion to early term are the severity of the original offense, your criminal history, compliance or non-compliance with the terms of your probation, the probation officer's recommendation. Usually they remain silent, which is considered a wink and a nod. They defer to the court. But their lack of objecting to early terming your probation is taken into consideration quite significantly. One of the things that I like to do is have a risk assessment evaluation done on my client by a licensed psychologist. This gives the judge something to hang their hat on in granting a motion to early term their probation. It basically gives them a basis to terminate supervision on the words of a licensed professional, an expert, a doctor who says that the risk of this individual committing new crimes is very low or practically non-existent. Remember, criminal court judges have a lot on their shoulders. They make a couple of bad moves. That results in the public not being protected. They let someone off probation. They go out commit more crimes and commit significant crimes and hits the media. They may not be sitting on the bench in the future after election year. Now, like I said, as of October 2019, there are circumstances where Florida law says that the judge must terminate an individual's probation. This is if that individual's term of probation is at least 50% complete, that they have absolutely completed every special condition, every condition of their probation in general, that they've had absolutely no violations. There's been no waiver of early termination in the original negotiation or resolution of the case. Here's an issue where the state attorney makes an offer to a defendant that includes their waiving a right to early termination. We see that sometimes with heavier crimes. That individual will not be able to come back in under non-discretionary or mandated termination under Florida's new statute, but they can go under non-discretionary. Also, an individual who is qualified as a violent offender will be precluded from mandatory termination. And here's the catch also, if a judge doesn't want to let an individual off of supervision, they simply have to make a written finding that the public's interest in being safe exceeds that defendant's right to early termination under the new statute. Now, if a judge is inclined to deny a defendant's motion for early termination of probation, if they're inclined to exercise their discretion under discretionary, if they're inclined to make a written finding as to why probation shouldn't be early termed under the new mandatory statute, that's a good forum for either you or your attorney to address the court with regard to modifying the probation. So, Judge, listen, if you're not inclined to completely early term my probation and cut me loose, I'm asking that you convert it to non-reporting probation, that you delete special conditions that I'm having a hard time with. For instance, attending treatment or therapy or sessions, maybe just are very taxing on your ability to make money for you and your family. And you can seek in that open forum to have the judge at least modify. You can ask the judge to waive the cost of supervision, or even in some rare cases, convert restitution payments to a civil lien if you do not have the ability to pay those restitution payments. So you never want to just give up completely if the judge is inclined to deny your motion to early term. You want to at least seek some modifications. Seek something that's going to loosen up the terms of your probation, make it easier on you, and possibly even ask the judge to at least considering the setting of an automatic termination if you keep complying with the terms at a future date rather than having to outlast the whole entire term of that probationary period. Ask the judge for some incentive to keep doing good. Now, honestly, when we talk about automatic early termination, this is something that would have been great to have addressed at the original disposition of your underlying case. This could have been something that you fought for at the very onset, an early termination date. And this is something that you can ask for once certain conditions are met, especially in cases where restitution is a big issue. If the prosecutor has agreed to a sentence of probation of, let's say, 5 years because they reasonably believe it'll take you that long to pay off the restitution, ask the judge or that prosecutor for some incentive to be early termed if you make those payments and pay off the total amount, let's say in 2 years. Ask for an automatic early termination if you meet those requirements at the disposition date. So that way you don't have to come back in and fight for it at a later time. This automatic early termination can also be conditioned on the completion of special conditions such as drug treatment or counseling by a licensed professional. You always want to get creative with this stuff at the time of sentencing or even at your motion for early termination of probation if the judge isn't inclined to grant it, because trying to clean everything up after the fact when you're already locked in is much more difficult than when there's the incentive to do something for you, whether it's at the original disposition of the case. Remember, everybody wants to move cases in that courtroom, the prosecutor, the judge, even the bailiffs who have to sit there for calendar calls and whatnot. So there's incentive, and that's the time when you want to negotiate. And also you want to be creative when you file the motion for early termination if the judge isn't so inclined to grant it, because they want to provide the incentive for you to keep doing good or the motivation to keep doing good. Now, when it comes to community control, otherwise known as house arrest, there's a lot of confusion out there, and rightfully so, because what you generally see when it comes to sentencing is a sentence that begins with house arrest, community control, and that's followed by straight probation. So what we'll see is, let's say, for example, 2 years of community control followed by 4 years of probation. Now, in these cases, you really have a two-step process. You're going to need to go before the court on 2 occasions. The first time is at the halfway point of your community control aspect of the sentence. In this case, 1 year in. So you file your motion to early terminate the community control aspect of your total probationary sentence. If that's granted, then you immediately begin the 4-year cycle of your straight probationary sentence. And what do you do then? Step 2, after 2 years, you go before the judge again on another early term motion to terminate the probationary aspect of the sentence at 2 years rather than 4. And one of the things that I always like to point out is that for those who are eligible for record sealing, as soon as you are early termed off of probation, it's time to apply. That's when the green light is right in front of you, and you can petition the FDLE for a certificate of eligibility to have your record sealed. You've completed probation, so there's nothing stopping you from filing. Do it that day. Don't wait for the laws to change and prohibit your ability to seek a certificate of eligibility. Don't sit around and observe for yourself how difficult it is to find employment with a criminal record. Move on it. As a matter of fact, I think that it's the single best argument to be made that you need to get off probation so that you can petition the FDLE and get this thing off your record and get on with your life and become a productive member of society. It's a great argument to be made. Now, moving on, things that you should include in a motion to early terminate probation are the date the defendant was placed on probation, the underlying offense for which the defendant was placed on probation, the special conditions of the defendant's probation, and whether or not they've completed those special conditions. They should all be outlined. An accounting of all fines, fees, costs, and restitution amounts, along with a ledger as to what fines, fees, costs, and restitution amounts has been paid. Very clear, very detailed, very organized. Disclosure regarding violations of probations and explanations, in addition to the resolution of those violations, if any. Obviously, no prior violation would be preferable, and so if you have no prior violations, make sure your attorney includes that fact in the written motion. Also include any recommendations as to the probation officer, the position of the state attorney handling the case. Submit an affidavit signed attesting that there have been no new law violations by the person under supervision. And what I always like to do, go the extra mile and have that favorable risk assessment evaluation included in the motion to early terminate probation. If you want more information about terms that I've used in this broadcast, go to my website, crime-lawyers.com. If you want more information about what administrative or non-reporting probation is, if you want the contact information for licensed professionals in the way of forensic psychologists in the South Florida area who are really good when it comes to risk assessment evaluations, go to crime-lawyers.com. Check it out. I've got a lot of videos on there.